good afternoon. Sunny afternoon, but also quite chilly afternoon, but it's very nice to be looking out the back of this classroom, which is actually one of my favorite classrooms for a range of reasons, and to see blue sky. But even better to see all of you here. I'm delighted to welcome you to the Faculty of Law. My name is Jutta Brunet. I'm the Dean of the Faculty, and I'm thrilled to be introducing this year's Goodman Lecture. Before we proceed, I would like to begin by taking a moment to pause and reflect on the land on which the University of Toronto operates. I came to the University of Toronto some 25 years ago now, and to Canada some 10 years before that. And in this time, I have learned a lot about the history that has brought us here. And so I want to acknowledge that for thousands of years, this has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and at the Faculty of Law, we are grateful to have the opportunity to learn, to work, and build community together on this land. The Goodman Fellowship was established in memory of the late David B. Goodman, QC. I guess still QC, probably, I don't know, unless rechristened to Casey, now that I say that for the first time, so I'm not sure, but he's a member, and it was created by members of his family, friends, and professional associates with the intention of bringing to the law school on an annual basis a distinguished member of the practicing bar or bench or a scholar interested in related issues for a few days of teaching and informal discussions with the student body and with our faculty. It was the intention of the founders of this fellowship that the Goodman Fellow would, on the one hand, bring to the faculty the benefit of insights and ideas gained from long experience in the law, and on the other hand, herself or himself be refreshed, we hope, by a short visit in the academic legal community here at the University of Toronto. I am particularly delighted that Diane Goodman, the granddaughter of the lecture's namesake and an alumna, and we're very proud of her as our alumni of our faculty, and her husband, Mark Vincent, are with us here this afternoon. Now, the list of Goodman lecturers is as long by now as it is illustrious. I would encourage you to take a look at the faculty's website. I'm fairly certain that you'll be dazzled by what you see there in terms of names of Goodman lecturers. We've been really, really fortunate to be able to host these annual lectures. They are a highlight of our academic calendar each year, and this year is no exception. We're really in for a treat. And while our Goodman lecturers don't tend to need an introduction, they most definitely deserve one. And so it's my great pleasure to turn things over to my colleague, Professor Carrie Rittick, who will introduce this year's distinguished Goodman lecturer. Carrie.
Thank you, Jutta. Let me add a very warm welcome to everyone and say that I'm absolutely delighted to introduce Professor Michele Goodwin to the Faculty of Law. Professor Goodwin is the Linda D. and Timothy J. O'Neill Professor of Constitutional Law and Global Health Policy at Georgetown Law Center in Washington, D.C. And very fortunately, she's also currently teaching an intensive course here at the Faculty of Law on reproductive rights and justice. I should say right at the outset that Professor Goodwin has one of the most dauntingly impressive CVs that any of us might ever expect to encounter. But let me just give you some of the highlights by way of illustration. Dr. Goodwin is an acclaimed bioethicist, constitutional law scholar, and a prolific author. She is currently the co-faculty director of the O'Neill Institute for National and Global Health Law, and previously she was a chancellor's professor at the University of California, Irvine, and founding director of the Center for Biotechnology and Global Health Policy. Her scholarship has appeared in virtually every leading US law journal, including Harvard, Yale, Chicago, Cornell, University of Pennsylvania, California, Michigan, New York, and Northwestern. Her work addresses an equally impressive range of legal questions around, for example, freedom of speech, the exercise of religious freedom, equal protection and due process, race and sex discrimination, reproductive rights, slavery, and LGBTQ equality. She is the author of 6 books, including the award-winning Policing the Womb, which I hope she shows you at some point today, Invisible Women and the Criminalization of Motherhood. And she has authored or co-authored amicus briefs submitted to the US Supreme Court, as well as the 2nd, 3rd, 6th, and 9th US Circuit Courts of Appeals. Her work has been cited by civil society organizations and both state and federal lawmakers. And in addition, she's widely sought as a public intellectual across virtually all forms of media, appearing in leading US publications such as The Atlantic, The New York Times, The Los Angeles Times, The Nation, Chicago Sun-Times, Vox, Politico, Salon, Forbes, The Washington Post, and Mother Jones. She's also can be heard on ABC News, CBS, NBC, MSNBC, NPR, and HBO's Vice News. And finally, she's the executive producer of Ms. Studios and the host of the popular podcast On the Issues with Michele Goodwin. As if that were not enough, Professor Goodwin has already amassed a fantastic legacy of leadership in social and political transformation, having guided one of the largest Southern school districts in the United States through desegregation, equity, and inclusion efforts. She serves on the executive committee of the American Constitution Society, as well as on the US National Academy of Sciences, Engineering, and Medicine committees, studying equality and access in technology, issues on organ donation, and currently on reproductive health. She was the first woman to be elected Secretary General of the International Academy of Law and Mental Health, and she is currently the president of the Law and Society Association and the Fellows Council of the Hastings Center. Okay, just a few more minutes. That's breathtaking, I realize. Her achievements have been recognized, as they well should be, by many awards, of which I can only mention a few. She is the 2023 recipient of the California Women's Law Center Pursuit of Justice Award, the 2022 American Bar Association's Margaret Brent Award, and in 2021, the Distinguished Senior Faculty Award for Research, which is the highest honor that can be bestowed by the University of California. She's an elected member of the American Law Institute, as well as an elected fellow of the American Bar Foundation and the Hastings Center, the leading organization on bioethics. Awards have come at the local as well as the national levels. In 2020, Orange Coast named her one of 35 kick-ass women. In 2019, she received the Be the Change Award. In 2018, she received the Sandra Day O'Connor Legacy Award by the Women's Journey Foundation, and she was named Teacher of the Year by the Thurgood Marshall Bar Association. Finally, she received a commendation from the US House of Representatives for outstanding teaching. I could actually go on, but I think I'll stop at this point and say we're incredibly happy as well as honored that she's agreed to deliver the Goodwin Lecture, and she's going to speak tonight on the topic of citizenship, the long and complicated arc of women's equality. Please join me in welcoming her.
Thank you. Thank you so much. Thank you. Thank you. Now, I do have a lav mic on, and you do hear me. First of all, I'd like to thank you so very much for that incredibly generous introduction. Thank you so very much. Dean Bruni, thank you so very much. And I'd like to thank the Goodmans and Diane Goodman, who is here. Diane, thank you so very much, and the legacy of your grandfather establishing this lecture series, and beyond it, the opportunity for lecturers to engage with the students. I can't help but think, with that incredibly generous introduction, as I sat through it, I thought about my maternal grandmother, and I thought about how proud she would have been if she had still been living to hear that. So thank you so much. And indeed, part of my lecture I could think about as being in her honor. She passed away what would be now 35 years ago. And she was from the state of Mississippi, which was the state that brought the challenge to Roe v. Wade, and which amounted to the decision that was in Dobbs v. Jackson Women's Health, the case that in 2022 overturned Roe v. Wade and Planned Parenthood v. Casey, a state that was notorious both during the time of American slavery and the period that followed during Reconstruction and post-Reconstruction, the period in the United States known as the Jim Crow period. It is an honor to present the 2024-2025 David B. Goodman Lecture. And amongst its past recipients are distinguished jurists and professors. One of my former colleagues and dean, Bryant Garth, presented quite recently. I think it was in the 2023-2024 term. There was the retired Honorable Lady Hale of Richmond, the former President of the Supreme Court of the United Kingdom, who presented on judicial independence and some of its enemies. One might argue that I come from a country where exactly that lecture would be so profound and timely. It's a pleasure to be in their company. This talk could very well be titled Citizen Gerrymandering, or what does it mean to be a citizen? What does it signify to be a person or not? What may seem obvious truly demands our close readings of history, honesty, and a fidelity to truth. I'll begin the lecture with a very brief reading from Policing the Womb, and as you've asked for an image, this is the cover of the book, and then lecture. This book is not a work of fiction, although I wish it were. Some of the cases described here could recall the imagery evoked by Mary Shelley, author of Frankenstein, or the modern Prometheus, who tells a horror story about a young rogue scientist who creates an unsightly monster through clandestine, aberrant experimentation. Although Frankenstein is the name of the monster's creator, Dr. Victor Frankenstein, readers would be forgiven for debating who the real monster happens to be. In Policing the Womb, the story of Marlise Munoz comes to mind, a brain-dead, decomposing woman in a Texas hospital forced by state legislation to gestate a barely developing fetus while her body decays and anomalies in the fetus mount. Eventually, it is reported that the fetus is hydrocephalic, which means severe brain damage in this case, and water or fluid developing on its brain. Medical reports also show that the fetus is not developing its lower extremities. The state knows brain death is irreversible. The hospital forces Marlise's dead body to shake, placing it on a bed that constantly, violently moves, which makes the dead eyes woman flap open and shut, likely frightening some hospital staff they decide to tape Marlise's eyes shut. Even if Marlise could see anything, which is unlikely because she is dead, now no one needs to look into her eyes to search for any signs of life. If the state believes, despite well-accepted medical science, that she is alive, it has now taken away her sight and forced her into a state of blindness while her body is poked and prodded. Marlise's shaking corpse stays hydrated through tubes that bring fluid into the body. Somehow the hospital finds a way to pipe away the waste. Everyone, including the state, agrees that really she is an incubator. This is why the Texas law exists. This is not the novel The Handmaid's Tale, a dystopian opus written by Margaret Atwood, made exceedingly relevant today in the United States. The shaking bed is not in the totalitarian fictional state of Gilead. No, this is Texas. This is why the state forces machines to be attached to Marlise's body to keep her organs functioning until they give out. The machines are not keeping her alive, they are simply keeping her organs viable. This is why the hospital cleaves into her body, slicing, lacerating, and stitching tools, tapes her eyes shut, pumps her with fluids, and then drains other fluids from what remains of her. Her decaying has nothing to do with senescence or aging. Rather, it is the typical decomposition characteristic of brain death cases. Hoses, pipes, and cylinders serve as the conduits between the state and Marlise's decaying body. This is known as mechanical support. The hospital cuts a hole into Marlise's neck to create an opening in the trachea. She will receive a tracheotomy. The widower, Eric, objects. This is a desecration of Marlise's body. The hospital must be used to ignoring Eric's objections. He said no and objected to the second resuscitation attempt. The hospital did it anyway. He sits there daily as her light brown skin transitions from supple to hard, like a mannequin, Marlise's father said. Her body loses muscle tone and begins to smell. Eric comments on the smell. That smell lingers. It is not the smell of Marlise's favorite perfume or flowers from the tidy hospital gift shop. No, the smell that fills the room and Eric's nostrils and those of anyone who visits the room is that of a rotting body. No one except perhaps the select group of anti-abortion protesters outside is confused about this. Marlise is dead. Outside, however, someone tells filmmaker Rebecca Hamowitz, just give Marlise a week. You'll see, he says, a week or two will turn this whole thing around, he says. This particular protester captured in Hamowitz's documentary, 62 Days, travels to cases like this. She told me that he's like a professional at this. A thought comes to mind. Sleeping Beauty, that 1959 animated musical produced by Walt Disney. It's based on the 17th century French fairy tale by Charles Perrault. In the fairy tale, a beautiful princess is forced into hypnotic slumber. The spell she is under will only be broken by the magical kiss of a prince. The prince will awaken her. However, Marlise's real-life prince, Eric, does not harness this magic. Or perhaps the state has dethroned Eric. But if that's the case, who is the new prince? The Texas legislature? In any case, Eric Munoz lacks any special powers to rouse Marlise, despite what the protesters outside the hospital claim. In fact, Eric no longer has rights over his wife's body until the state is satisfied with Marlise's gestation and cuts open her body to remove the fetus. It turns out that marriage and the rights of the next of kin mean very little when the state takes control of a pregnant woman's body in order to protect the fetus. The state refers to this as fetal protection. In this case, the state is protecting the fetus from Marlise's husband and her parents, who say, "Let her rest in peace." That's how I introduce this book. During the work of researching in this book, I spoke to Marlise's parents, to her mother. I spoke with and spent time with the filmmaker, Rebecca Hamowitz. And the book itself was a work of 10 years in progress. It was a book that I thought that I would write in 2 years, but as more and more cases mounted, as more and more I communicated with and interviewed prosecutors, as more and more times that I worked with lawyers or served as an expert witness, there was more time that was necessary to form my thoughts. This book was published in 2020, warning about what the future would be. And in 2022, the Supreme Court overturned Roe v. Wade and Planned Parenthood v. Casey. What is the requiem for Roe v. Wade? In 1973, in a 7-2 opinion, exactly 100 years after the Supreme Court upheld states' laws barring women from suffrage in Minor v. Happersett and practicing law in Bradwell v. Illinois, the Supreme Court acknowledged the disturbing social conditions associated with centuries of shaming, stereotyping, and stigmatizing women when it struck down laws that criminalized abortion. In doing so, the court finally recognized the detriment that states had long inflicted on women when legislatures denied them choices about their reproductive destinies and aspirations beyond motherhood or being bound to their husbands. Although unstated in Roe, the court also initiated the work of dismantling its ugly record of complicity in affirming harmful laws that tethered women to motherhood. Laws banning women from full participation in society and suffrage, arguably rooted in coverture. The troubling legal theory advanced by Sir Matthew Hale and Sir William Blackstone that women's identities and legal rights subsume within the bundle of rights that are possessed by their husbands. Such laws were never meant to enrich women or to recognize their constitutional personhood, but rather to secure familial harmony for men, even to the detriment and abuse of their wives and their daughters. According to Blackstone, quote, "By marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of her husband. Supposedly, a woman gained protection from being under her husband's wing, protection and cover, hence coverture. Blackstone declared that wives were to, quote, perform everything and is therefore called in our law a femme covert. In 1736, Sir Matthew Hale his highly acclaimed treatise, Historia Practicarum Coronae, History of the Pleas of the Court, or the Crown, declared that it was inconceivable for a woman to be raped by her husband. Hale argued that, quote, a husband cannot be guilty of rape because marriage conveys unconditional consent, whereby wives have entered a binding contract and hath given up herself in this kind unto her husband, which she cannot retract. Importantly, no prior English common law articulated this standard, but this rule found broad support amongst parliamentarians and subsequently influenced legal developments in the British colonies in the United States. Nearly every state legislature in the United States enacted laws that safeguarded husbands from criminal punishment for raping their wives and sometimes even their girlfriends. The harmful vestiges of such principles instantiate deeply in law and remain very difficult to uproot. Finally, in 1993, North Carolina rescinded its marital rape exemption. Until that time, all states protected individuals who were men that raped their wives during marriage. Egregiously, in Dobbs v. Jackson Women's Health Organization, the decision authored by Justice Alito that struck down Roe, the court returned to Blackstone and Hale. In doing so, the court invoked legal theorists who refuted that women possessed any identity apart from their husbands. Hale and Blackstone also rejected the recognition of marital rape and thus denied the principle that married women could defend themselves against sexual violations committed by their husbands, seemingly because Hale and Blackstone espoused the view that marital rape was non-existent, so too did states' legislatures. Undoubtedly, Blackstone and Hale provided convenient cover for male legislators already inclined towards patriarchal interpretations of law. In a society that also embraced and greatly profited from slavery, race and sex hierarchy served as the architecture and the organization of American life, not only in southern states, but also in northern states as well. And problematically, American courts became complicit in upholding very dangerous patriarchal ideals and citing Blackstone and Hale in justification of invidious norms violating what can be described as minimum standards of the rule of law. And in my talk today, I want to take us through aspects of this. In other words, in their advancement of the views that domestic corrections were unpunishable or sexual assaults non-existent in marital relationships, these ideologies became incorporated in American jurisprudence. Lower courts came to interpret domestic violence as inoffensive to law. In North Carolina, while the Supreme Court eventually rejected the idea, that is, the North Carolina Supreme Court, while it eventually rejected the idea that wives could be subjected to whippings, the court nonetheless maintained, quote, if no permanent injury has been inflicted, nor any malice, cruelty, nor dangerous violence shown by the husband, it is better to draw the curtain and to shut out the public gaze and leave the parties to forget and to forgive. In Abbott v. Abbott, the Supreme Court of Maine denied relief for a married woman whose injuries were so severe as to require hospitalization. According to the court in that case, quote, husband and wife are one person, and as such, Mrs. Abbott was denied recovery. Now, this sophistry extended to daughters as well. In the case Roller v. Roller, the Washington Supreme Court held that it would undermine public policy if victimized teens could recover after being serially raped by their fathers. Evidence of the sexual molestation in that case was not at issue, as sufficient proof was provided at the lower court during adjudication. Rather, as the justices explained, the preserving of domestic, quote, harmony took priority and manifested from, quote, the earliest organization of civilized society, and inspired by the universally recognized fact that the maintenance of harmonious and proper family relations is conducive to good citizenship and therefore the welfare of the state. One would only ask whose harmony was being protected in those cases. And these cases are not isolated. This essentially was the rule of law in the United States. Judges alleged that spousal and familial immunity responded to important policy goals, including discouraging intrafamilial litigation. As Reva Siegel explains, courts claim that interspousal litigation violated fundamental precepts of the doctrine of marital unity. Judges ignored that minimizing marital tensions and discord for men did not alleviate tensions for women. Further enshrining marital harmony as a priority in American jurisprudence did not serve women or remedy physical, emotional, and sexual abuse that they experienced in their marital homes. Now, the history of all of this is important to unpack. And that's what I would like to turn to, which is that Dobbs is not a manifestation of the fact that Donald Trump, prior to securing the 2016 victory as president in the United States and the ability to appoint 3 justices to the Supreme Court, which was significant and is so significant in so many areas of law. But it is not that alone that really sets into motion or sets the foundation for what it is that is being experienced in the United States at this time. In order to truly understand it is to, in fact, appreciate and to examine more of U.S. history and more of its foundations. And to understand those foundations really does mean paying attention to American enslavement, the enslavement of black women and girls. The first questions, both about citizenship and as well reproductive autonomy, actually take shape when we unfold and unpack those periods in our history. And in fact, as Justice Blackmun noted in Roe v. Wade, abortion had not always been criminalized in the United States. And in fact, the criminalization of abortion itself is directly tied to the abolitionist movement to free black women from slavery. You may recall that there was broad political, not so much debate, but broad attention to an 1864 anti-abortion law in Arizona, before Arizona actually became a state. This is 1 year before the 13th Amendment, which abolished slavery. The very laws that were set in motion to criminalize abortion were directly related to what is called replacement theory today. This concern that somehow with greater immigration will lead to the deepening of the browning of the United States, but that too is not new. These were the concerns that were being raised as the drumbeat towards the end of slavery were mounting. And it was a bit of an imperfect storm that was coming together. That is to say, as abolitionists were thinking about what were the best tools to be utilized in order to dismantle slavery, they landed on something that was landing on their tables every morning and afternoon. That is newspapers. And these newspapers carried advertisements. And these news advertisements made very clear what American slavery was invested in. These news advertisements that advertise for breeding wenches, that advertise gangs of breeding wenches for sale ages 18 through 14. These advertisements, after the passage of the federal law, the Fugitive Slave Law of 1850, that advertised for the return of individuals who had escaped. But these advertisements, and there are tens of thousands of these advertisements, people read them as they drank their morning coffee, in the afternoons as they came back from work. And these advertisements made clear what American slavery was truly about, particularly the ones such as Maria, 16, has escaped with her 2-year-old mulatto child with a name. And over again, these advertisements planting a seed and exposing what American slavery truly was about. In 1861, Harriet Jacobs penned the illuminating and enduring memoir, Incidents in the Life of a Slave Girl, adding an important narrative and witness account to the canon of American history that roots in this early story about reproductive health, reproductive rights, reproductive justice in the United States. If de Tocqueville's Democracy in America compellingly captured the new nation's dream, Jacobs revealed the nightmare. She presented a chilling examination of antebellum America captured through the lens of a child, an enslaved girl trapped in the hungry and predatory grasps of American slavery. The despair that dripped from her pen landed in terrifying prose about sexual violence, forced pregnancies, and efforts to escape those terrifying realities. Her autobiography exposed a system of laws, practices, and behaviors far less gentle and kind and more sinister than the labor-focused accounts of slavery that largely center on men, forced, uncompensated production and harvesting of cotton, rice, tobacco, and sugar. Rather, the horrors that Jacobs recounts, kidnapping, sexual coercion, confinement for the purposes of sexual abuse, rape, and torture, the far too common terrors of chattel slavery demand a far more nuanced view of the period. Jacobs provided a view into a largely neglected archive of American legal and social history, now made increasingly relevant by the Supreme Court and the contemporary debates involving forced pregnancy, reproductive freedom, and abortion. By no means alone, in 1851, in a powerful speech, an oration recorded as "Ain't I a Woman?" Some of you may have heard of this or the referencing of it. Sojourner Truth implored a crowd of men and women gathered at the Women's Rights Convention in Akron, Ohio, to consider the gravity and utter depravity of American slavery in the lives of Black women. It was an appeal not only to abolish slavery, but to understand its unique toll in the reproductive lives of Black women. Reported by newspapers and recorded through history, Miss Truth stated the following: "And I bore 13 children and saw nearly each one snatched from my arms, and nobody heard my cry but God, ain't I a woman?" And it was a speech that was delivered 1 year after the Fugitive Slave Act was put in place. The Fugitive Slave Act was particularly despairing for those who would seek to escape the grasps of American slavery, because it provided that individuals could weaponize what the law provided for, and not only seek individuals who had actually escaped from Florida and Texas and Georgia and Alabama and other places trying to make their way north to Massachusetts, to Pennsylvania, et cetera, but they could also try to grasp and obtain, kidnap individuals who had always been free. It's the subject of the Prigg case, in case any of you teach that particular case. But what is so helpful for us who are historians of that period are the cases that then come about, not necessarily through legal disputes, but what is recorded in newspapers after the 1850 Fugitive Slave Act, just as Sojourner Truth's powerful speech is recorded in 1851. And by no means rhetorical, Truth touched on a profound matter of human rights, hotly debated in American law. Was she, and for that matter, all other non-manumitted black women, property, and therefore with no rights to appeal to a court? Did they have any rights that a court was bound to respect? Or was she a woman and therefore entitled to the legal protections that were accorded white women? Was she mere property and therefore not worthy of privacy? One important aspect of the fugitive slave law was the fact that individuals who were captured were denied the ability to actually speak before the magistrates that they were brought in front of. So they could not tell a narrative about how long they lived in Baltimore or were born in Baltimore or Boston or anywhere else. Another feature of the 1850 fugitive slave law was that magistrates were paid double if they found that these individuals were actual escapees of enslavement, providing a perverse incentive in American law. Now, the answers to these questions that I've just posed mattered not only politically, but they also mattered economically. In a letter to John Wales Epps on June 30th of 1820, Thomas Jefferson wrote, "I know no error more consuming to an estate than that of stocking farms with men almost exclusively." He went on to write, "I consider a woman who brings a child every year or two as more profitable than the best man of the farm. What she produces is an addition to the capital, while his labors disappear in mere consumption." Notably, Epps was a politician as well as a relative of the former president. At the time of Jefferson's epistle, lauding the economic gains to be wrought from exploiting black women's forced reproduction, labor, and servitude, Epps had already served in the Virginia House of Delegates as well as the U.S. House of Representatives and the Senate. He was also Thomas Jefferson's nephew and an owner of enslaved people. Thus, while this was an exchange amongst businessmen with family ties, it was also a communication amongst politicians who shaped state and as well federal laws. Across a series of events in the 1850s and 60s, these matters would be contested and sorted at trials and even before the United States Supreme Court. Whether black women were property, entitled to privacy, shared the legal status of white women, at least regarding to rape, were questions that dominated the concerns of abolitionists, including those who were in Congress. By the late 1850s, the tragic narratives of women like Sojourner Truth, Harriet Jacobs, Margaret Garner, and Celia Slave, among others, were central to the concerns that were on the minds of abolitionists. They are once more relevant in light of the Supreme Court's decision in Dobbs. In the wake of a 10-year-old rape survivor fleeing Ohio to obtain an abortion in Indiana just mere days after the Dobbs decision, it was like a page that was literally ripped from history. And the case of Margaret Garner comes to mind. Margaret Garner, her story is memorialized by Toni Morrison's Pulitzer Prize-winning book, Beloved. And some of you may remember that story of Beloved. Margaret Garner fled a Boone County, Kentucky plantation and the Gaines family, which claimed ownership of her. In the frigid depths of winter on January 27th, 1856, a 22-year-old and pregnant Margaret Garner safeguarded her meager belongings and escaped on foot with her children, a mule, and companions. To understand the geography, Kentucky is just south of Ohio, and in Cincinnati, which was in southern Ohio, was a place in which escaped black persons could be free. Margaret was trying to get to Kentucky, to get to Ohio. What separates Kentucky and Ohio is a river, the Ohio River. Margaret's goal was to reach Cincinnati, a key stop on the Underground Railroad, a place of at least temporary respite and safety for escapees brave enough to risk physical punishment, whippings, the chopping of limbs, and even death if caught for running away. Such cruelties were strong disincentives against attempting freedom, and without federal protections, black women and girls were incredibly vulnerable. State and federal laws even punished individuals who aided and abetted so-called runaways or fugitives from slavery. For Margaret Garner, she didn't have, as I've shared with my class, the benefit of those very warm Canadian goose jackets. She didn't have the benefit of the kinds of boots that we wear. Her clothing was quite meager as she and her children attempted this escape and to cross a frozen river in order to get to freedom. And she did, in fact, make it across that river. And as she made her way across that river and found safety and shelter, it was not long before fugitives came after her. And then the crux of really what this talk is about on that frame of citizenship, on the frame of personhood truly comes to mind. It is said that as Margaret heard the dogs and the hoofs and the calls, that she picked up her first child and picked up a knife and slit the child's throat. And as they came and burst through the doors, she had picked up the second child when she was overtaken. And it is said that she called out that she would rather her children die than for her children to be subjected to what she had already endured in the 22 years of her life. This question about personhood and citizenship crystallizes in Margaret's case, because in her case, she was provided something very rare, which was legal counsel. One can argue it was so because in Cincinnati, black persons could be free. And the argument that was made by the lawyer who was representing Margaret was that she should be charged with first-degree murder for the killing of her child. And then you might wonder why it would be that a lawyer would actually want a client to be charged with murder. But it crystallizes under this question: were black women property? Were they simply chattel? Or could they be persons? And the only way that seemed visible for Margaret to be attached with personhood would be that she would be criminally charged, because otherwise she and her children in the American establishment of laws, both state and federal laws with the Fugitive Slave Act, right, was that their status was no higher than an animal in the field. In the state of Kentucky, Margaret's status was not one of personhood. It was a life that was no higher than that of a dog, a mule, a cat, an animal in the field. And this question in Margaret's case, in terms of her status, became one that was written about not only nationally, but also internationally. It was incredibly important. If Margaret could be a person, then this meant that everyone who was like Margaret, trapped in the systems of slavery, would too be human beings and call into question slavery itself. Notably, Ohio was a free state on paper, but a complicated one at best. Lawmakers abolished slavery years before, and in 1841 even allowed black people who made their way to the state to claim freedom. However, according to Julius Yannick's illuminating work on the Garner case, quote, in Southern Ohio, there was a marked antipathy towards abolition, and lawmakers were hostile to black refugees escaping the torment of slavery. In Margaret's case, she is ultimately provided back to the man who owned her, and she dies before the age of 25. By January of 1856, Margaret was desperate to be liberated from the sexual abuse of Archibald Gaines, and that was why she had sought to escape, and the intergenerational physical abuse and psychological torment that she and the women in her family had endured on that plantation. She was the daughter of an enslaved black woman who is believed to have been raped by John Pollard Gaines, a prominent politician, and her mother's owner. Being the daughter of a slaveholder did not spare black girls and women as they took on the status of their mothers, not their fathers, which shielded white men from economic and moral responsibility for their black offspring and allowed them to hold their children in bondage to mortgage, rent, and to sell for profit. It is, in fact, something that Thomas Jefferson famously did too. Thomas Jefferson, when his wife Martha passed away, he called for her sister, who was black, half black, Sally Hemings, to be brought to him in Paris. She was 13 years old at the time. And the agreement that she struck with him, if she were to return to the United States with him, because in Paris she could be free, but the deal that she struck with him was that their children would be set free. She returned to the United States pregnant. There were 6 children that they had together. He never set any of those children free. Margaret Garner's case is not alone. There are other cases that became newsworthy of the time, right in that very same period, that brought attention to what was taking shape in the bowels of slavery in the United States. And it was from that that abolitionists used as a platform their fight against American enslavement. In fact, for Charles Sumner, who became an author, who participated in the drafting of what would become the reconstructed Constitution and those amendments, the 13th Amendment, which abolished slavery and involuntary servitude, the 14th Amendment, which provided citizenship and equal protection under laws to black people, and also the 15th Amendment. As a participant, as a drafter in those decisions, he was a person who was intimately familiar with the costs of that system. For Charles Sumner, he was beaten nearly to death in the halls of Congress only days after having given a speech about the kinds of horrors that Margaret Garner and others like her had experienced. And the speech itself was called Rape. And it was the few days after giving that speech, placing in stark detail exactly what the costs of American slavery were, that a representative from South Carolina accosted him with a cane, and with that cane beat him nearly to death, so much so that he left, he could not serve for 3 years while he recuperated. Now, as I bring forward, in preparation for close and any questions and comments that you have, when we think then about Roe v. Wade, for all of the criticism that has been directed at it, from its trimester framework to important critiques that it centered the concerns of doctors, Roe acknowledged that unwanted motherhood could be oppressive and dangerous. The ruling directly challenged the premise that a woman's destiny was confined to motherhood and heterosexual spousal care. The enduring profundity of Roe is that a century after the Minor case, Bradwell, Goodall, and many tragic stories of forced and involuntary motherhood during slavery, Roe articulated that motherhood and childbearing could be injurious to women. According to Justice Harry Blackmun, the author of Roe, to force or to coerce women into those destinies violated their rights to privacy. Justice Blackmun wrote, maternity or additional offspring may force upon a woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There is also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family already unable psychologically and otherwise to care for it. Blackmun understood that and undertook a rigorous empirical review, and a century after Minor and Bradwell v. Illinois, Bradwell being the case that denied women the opportunity to become lawyers. In that case, it's worth noting in Bradwell v. Illinois, Mrs. Bradwell was married to an attorney, so she very well knew what it took to become an attorney and what that was like. And when she petitioned the Supreme Court so that she too could become an attorney, and petitioning the court that the Illinois law that barred women from becoming attorneys should be struck down, what the court issued in its decision was that women not only lacked the capacities for the civil strife that was encountered in being a lawyer, but that also women were best suited for the care of their husband and their children. Now, notably, that was actually not what Mrs. Bradwell had petitioned the court for. She had not petitioned the court to tell her anything about her marriage. She had not petitioned the court to make claims with regard to children and motherhood, but it was, in fact, a petition to the court that would allow her and women similarly situated to become lawyers. As I conclude, I want to turn back to Mississippi. Mississippi was a state that during the period of antebellum was a place in which black people did not want to be sold to. It was a place that was known for its incredible violence. It was a place that not until 2013 did it ratify the 13th Amendment, the 13th Amendment having been ratified and made a constitutional amendment in 1865. And it's that Mississippi that brought us the challenge to Roe v. Wade. And I mention it because as one thinks about the Dobbs decision and Mississippi being the court that petitions the court in the overturn of Roe v. Wade, I'm brought to think about what I found to be a quite profound lower court decision, district court opinion, which was written by Judge Carlton Reeves. And in his order in 2018, which issued an injunction against the Mississippi law, and I think that that's, for the students here, it's a point worth noting just in terms of lawyering, that this was not immediate. The injunction in 2018, the decision in 2022, it's worth noting what took place in between. In 2022, there was a different Supreme Court. Justice Ruth Bader Ginsburg died in 2020. The court becomes different when Justice Amy Coney Barrett comes into the court, and of course with Kavanaugh and also with Gorsuch. But as Judge Carlton Reeves explained in a 2018 order enjoining the Mississippi law at issue in Dobbs, he said that legislation like HB 1510 1510, which was that Mississippi law, is closer to the old Mississippi. Mississippi had attempted to justify its law, claiming that its anti-abortion law was for the protection, health, and safety of women. It's worth noting that even the Supreme Court has recognized that an abortion, that a woman carrying a pregnancy to term is 14 times more likely to die than having an abortion, and that the World Health Organization has associated the safety of an abortion to a penicillin shot. But anyway, as I close, as Judge Colton Reeves explained in a 2018 order enjoining the Mississippi law at issues in Dobbs, he said that legislation like HB 1510 is closer to the old Mississippi, the Mississippi bent on controlling women and minorities, the Mississippi that just a few decades ago barred women from serving on juries so that they may continue their service as mothers, as wives, and as homemakers. And as I conclude, the scale of the harms that are brought about by the post-Dobbs era cannot be described as anything less than significant and tragic, nor would it be appropriate to describe the cases of near death and desperation as isolated or episodic, or the actual confirmed cases of death, or of the women being helicoptered out of states to get to states where their miscarriages can be managed. Sadly, threats of criminal and civil punishment for aiding or abetting in the termination of a pregnancy now shape whether and how medical providers will care for their patients. And despite assurances otherwise, the Supreme Court has set the stage for dismantling all other constitutional protections rooted in privacy jurisprudence, same-sex marriage, contraception, interracial marriage, and more. Despite hollow assurances that only the right to an abortion was being stripped away in Dobbs. Indeed, in a stunning concurrence, Justice Clarence Thomas dismissed substantive due process as, quote, an oxymoron that lacks any basis in the Constitution, warning that the court reconsider all of its substantive due process precedents, including that in Griswold, Lawrence, and Obergefell. And I thank you very much for your attention this afternoon.
All right. Thank you, first of all. I think we all need a moment. That was quite powerful, and we are now hoping to engage in conversation with you, but I imagine it will take people just a little while to digest.
It's depressing.
It is, well, you used that word, it's thought-provoking, I would say for sure. So I will try my best to keep track of who wishes to ask questions in the order in which they can appear. And we have someone here who will run with a microphone. And if you wouldn't mind, before you ask the question, to just briefly introduce yourself. And I would also encourage, to the extent that there are students here, I see some, please do ask questions, and I will make sure that we have time to hear your questions as well.
Thank you for that. Yeah, my name is Sasha. Basically, you touched on slavery and women's rights, and these are very important topics, especially because currently we live in a world where slavery continues to exist in countries like North Korea, China, Mauritius, Eritrea. And then women's rights, we live in a world where gender apartheid exists in Islamic countries, in Iran, Afghanistan, inheritance rights, and for women's rights, supervision by males. So do you think that the reason that the system in the US has moved towards that kind of more conservative Dobbs ruling has something to do with the other side, that this kind of problem of not addressing worldwide injustices that happens just because these are nations that are considered to be more left-leaning, so more left-leaning judges and politicians and policymakers, they never talk about much about gender apartheid. They don't really talk about slavery in these other countries just because maybe they're not such an easy target as a liberal world order nations are. All of us understand, if you travel to many nations or if you're from somewhere else, you know how much it is to have freedom of speech. In a country like Iran, you'll be hung if you say the wrong thing. How much of that blame should be shifted back to the left side of the aisle that has remained quiet on an international scale, giving ammunition to the right to now take away some of our rights, because it seems like there was a intellectual dishonesty there.
And there's a question up front. So thank you very much for that, Sasha. The first that I'll say is that the U.S. has prioritized an exceptionalism that is rooted legislatively and also judicially. The exception being in modern jurisprudence related to dismantling laws that would criminalize same-sex activity. So the U.S. tends not to look abroad as the basis for how it governs or how it conducts itself amongst its courts. An aspect of what you ask is really important, right? How does one understand the political divide in this space? And are liberals implicated here? So there are a couple of things that come to mind. Roe v. Wade was a 7-2 decision. 5 of those 7 jurists were Republican appointed. In Planned Parenthood v. Casey, which came 20 years later, it's a split decision. The majority in that case, each one of those jurists are Republican appointed. I mention that because part of the narrative post-Dobbs has been that this has been a conservative agenda all the time, and it's wrong. It's like taking hammer and nail rather than being far more nuanced. It's not the case. George H.W. Bush, who was the first of the Bush presidents, his father, Prescott Bush, was the treasurer of the National Planned Parenthood. This has not been a Republican agenda. But to your point, how are liberals implicated? One could look and say that there has been a sleepiness at the wheel, where there has been the failure to actually pay attention to certain critical issues. You note that the title of the book is Policing the Womb, and part of what is discussed in the book was the lead up to the moment that we're now in, where there were progressive organizations that were specifically rooted in reproductive rights that paid virtually no attention to what was happening, because what was taking shape was the criminalization and the policing of Black and brown women. Literally cases of Black and brown women being dragged out of hospitals in shackles and chains, women who wanted to be pregnant but had confided in their medical providers that they had used an illicit drug during their pregnancy. Now, we can debate the morality of that and the ethics of that and whether it's smart or not. I don't think that people should be using illicit drugs during their pregnancy. But that aside, notable that the organizations that were deeply invested in paid no attention to the fact that during the period in which those women could have had abortions, 10 weeks, 14 weeks of pregnancy, 16 weeks of pregnancy, being policed and punished because they had informed a medical provider that they had used a drug during pregnancy. And there was no aid rendered to those women whatsoever. And one very well could have seen those women as the canaries in the coal mine, that if state actors were already presuming a personhood in their fetuses, that at some point it too would affect abortion. And the one last point that I will make is that one significant failure that one can see with a reproductive rights agenda was that its agenda centered primarily around abortion, rather than, if you think about civil rights, the concerns are about access to education, housing, employment, accommodations, all areas of it. But a reproductive rights agenda that focuses primarily on abortion then misses women who wanted to be pregnant, wanted to maintain their pregnancies, to survive them and to have them with dignity, which then is a centuries-old question that brings us back to Sojourner Truth, ain't I a woman, right?
Thank you. Please.
So front.
Thank you so much. My name is Buki, and I'm a PhD student at the Department of Criminology and Social Legal Studies here at the University of Toronto. Thank you so much for your talk. My question borders on something that is quite concerning in the country where I come from. I'm from Nigeria. About 2 weeks ago, a 15-year-old girl poisoned her husband and two of her husband's friends. They had just married 2 days prior to the poisoning, and the husband didn't die, but one of the friends died. We've seen repeated cases of that, where underage girls who are married off, forcefully married off, poison their husbands as a way of rebelling against that practice of forceful marriage. Now, my question is on, I wanted to get your thought on how you think human rights advocates like me, in a deeply patriarchal society like Nigeria or many African countries, can go about this advocacy, especially in a country like Nigeria where there's a pluralistic nature of our laws, not just the formal laws like constitution, but also the religious and customary laws coexist. And some of these religious and customary laws permit the marriage of underage girls. And then when that happens, these underage girls are married. They tend to, do things like poisoning their husbands. And when that happens, they are then tried for the first-degree murder of their husbands or their husbands' friends. It takes the conversation away from the fact that they were married as young girls in the first place to the fact that they have now murdered someone. Yeah. And so no one is talking about what is happening to them. And lastly is also the issue of marital rape. In 2015, the Nigerian government passed the Violence Against Persons Prohibitions Act, a well-celebrated law that redefined rape, but completely silent on marital rape. No law in Nigeria currently prohibits marital rape. And so it furthers the conversation that women are still being seen, not just in Nigeria, but in many African countries, as chattel, as properties that should be owned. And when you own a property, you can do with that property howsoever you think. So I wanted to get your thought on that. And I'm asking this question because I know many countries learn from, advanced countries like Canada, the US, the UK. But before those lessons trickled down to our countries, many people would have died. Not just the husbands who choose to marry underage girls, but young girls would have also died in prison. Let me get your thoughts on that. Thank you.
Well, I appreciate your being here, and thank you very much for attending this lecture. What you've asked sounds like we should spend much time together in terms of unpacking that, and I hope that I can do service to it with a few thoughts that come to mind. The first is that I would also guard against a kind of African exceptionalism. While it is true in Nigeria and other countries in Africa that we can point to some where FGM, questions with regard to breast ironing, for example, that come up, FGM, and so forth. Africa is not alone, right? I've just been talking about the United States, a 10-year-old girl after the Dobbs decision having to literally flee in the same kind of scenario as Margaret Garner more than a century and a half before to get to another state in order to have a pregnancy terminated, right? That's the US. In the state of Idaho, women being airlifted out of Idaho who are in active miscarriage where their lives are in danger because doctors in that state fear providing care. In the state of Texas, to provide care to someone near death But where the state has not permitted the termination of the pregnancy, the doctor risks losing a medical license to practice, 99 years incarceration, and a $100,000 fine for each time. In North Carolina and South Carolina and also Louisiana, there are lawmakers that have called for the death penalty of doctors who would intervene and help women who are in crisis. The kind of women who've come forward after Dobbs with cases of gestating deceased fetuses and still the state not allowing the pregnancy termination to go forward. Women gestating fetuses that have no skull development and the state still forcing the pregnancy to occur. In a post-Dobbs reality, children now entering elementary and middle school in the United States as mothers. And so we could look to Africa, but we could also look to Florida. We could look to Nigeria, but we could look to Texas. We could look to Tennessee. We could look to Alabama and all of those places. We could look to Idaho, right? We could look to the fact that there are parts of the United States that have higher rates of maternal mortality than parts of Kenya, right? Now, that all said, we could also examine this question. We were just talking about this last night at dinner about underage marriage. It's actually something that I've spent time studying, spending time in South Africa about it, parts of India, and the Philippines, et cetera. So I understand that question. And interestingly, there too, we struggle with this in the United States. There are states where efforts have been made by lobbyists to secure minimum age for marriage that would be associated with adulthood, because there are states in the United States where you can be married at 14. There are cases in the United States, even within the last 10, 15 years, of 10-year-old girls being married, so long as their parents give consent, right? So those same questions that we could look to Africa about right here in the United States, we are contesting and considering. And the final point that I'll make is that what you have offered reminds me of a case that I also talk about in this book. It's the case of a 15-year-old girl, she was 15 at the time, named Renee Gibbs, also from the state of Mississippi, who was charged with depraved heart murder after she had a stillbirth. And she was charged with depraved heart murder. She had a stillbirth, and she had acknowledged to her medical providers that she had used an illicit drug during the pregnancy. Mississippi has a statutory rape law, and Renee Gibbs would have otherwise qualified as being perceived as a victim of rape. But the state never pursued that. Instead, what the state pursued was that she should be charged with a crime of murder because she had a stillbirth. So much more to discuss, but I just wanted to illuminate more of the synergies than the disparities.
And we'll go to Rebecca. Also in the front row, sorry, I'm not very clear here.
Thank you, Professor Goodwin, for a very sobering picture of the origins of the Dobbs ruling. I'd like to ask you about your criticism of the reproductive rights movement and what you would prescribe in terms of its fragmentation, its overuse on the abortion problem without regard to miscarriage management, stillbirths, as you just discussed, looking at healthy birth outcomes and the conditions that women need to ensure healthy birth outcomes. And in addition to this problem of fragmentation within the movement, what sorts of frameworks for equality do you think would be useful in building, going forward, in building a more constructive movement to address some of these problems?
Well, thank you very much for that question, and thank you very much for your important work. Everyone who's in this room should know about the important work that you have done globally in trying to secure better health outcomes and recognition for women and girls around the world. And so thank you very, very much for the work that you've done. And thank you for being here. 30 years ago, a group of black women convened in Chicago to address this question of what would be a better framework than what was being seen at the time. In part, they were responding to an era that had emerged in the United States. And I want to just take one moment that further gets us back to this question about this sort of, this line that we could draw, a spectrum that we could draw from slavery to the present, because it's really important. We're missing everything about Dobbs if we think that this is just the moment of today, or we think that it's a moment that is of the last 8 years, 9 years involving Donald Trump. The fact that in 2015 he said, if I'm elected, I want women to be criminally punished if they want to have abortions. For people who see that as this explains it all, that's ridiculous. I mean, it really is, because you can really see the line, right? And that line takes us from slavery into the present. And so those women who gathered in Chicago wanted to come together with a different framework. And they were responding to an era, kind of perfect storm, or imperfect storm, if you will, that had come together. Part of that storm included the narrative of the welfare queen, right? For any of you who are interested more in this, you could, consult the work of my former colleague, Karen Gustafson. But the welfare queen narrative was one that was evoked by Ronald Reagan when he was running for office to defeat Jimmy Carter. And this is very interesting. And again, what's old is new, right? Because Reagan sets out on his campaign, for those of you familiar with his legacy, he was a governor from California. You might say that a governor from California who's launching his campaign wants to go perhaps to New York, right? West Coast, East Coast, or to Boston. Or maybe it's in Chicago in the Midwest. Or maybe if it's south, it's Florida or Texas. But that's not where Reagan goes to launch the narrative, which becomes powerful and profound in his campaign. Where does he go? He goes to Mississippi. And where in Mississippi does Reagan go? Now, Reagan could go to the University of Mississippi in Oxford, right? I want to be affiliated with a campus and an intellectual environment, and that's where I will launch my narrative. That's not where he goes. There is a very famous case from 1964 involving James Chaney, Mickey Schwerner, and Andrew Goodman. And some of you may remember this memorialized in the film Mississippi Burning. But it's 3 young people, 2 of them Jewish and 1 of them black, at a time in which the beat of the civil rights movement is growing stronger and stronger, just like that beat of abolition from slavery. Now here's the beat, right? One could call it a second Reconstruction. Is literally 100 years after the other. And you've got these young Jewish boys and this black boy from the South, and they are together and they're part of the Freedom Riders in this Freedom Summer where they're going to help people be able to register to vote, to teach people. And they go south. Sometimes I show a slide of Andrew Goodman's note to his parents, which always breaks my heart whenever I do that, and I get caught in my throat, because in this note, it says something to the effect of, Mom and Dad, I've arrived. The people are treating me well, right? It's the last postcard that they will ever receive from him. It's the last word that they will ever have from him, because after these young men leave a church, they're arrested by law enforcement. And after they are released, law enforcement again tracks them down along with members of the Klan, and they kill them. And you may recall an image of Dr. King holding up a poster, a wanted, it's looking for them. They're wanting to find them. And it's the family of the Jewish boys who say that the only reason why they were found is because they were white. And during the process of searching for these 3 young men, they find so many young black folks. Now, why do I mention that? It's because that's where Ronald Reagan goes to do this speech. A governor of California, of all of the places you could go because you want to be president and make a fancy speech, you go to Philadelphia, Mississippi, only known for this notorious act. And on that platform, to create a new narrative, this narrative about the welfare queen. And the welfare queen has a face, and it's a black face. These women who are dregs on society, that are having too many children, that are really punishing our economy at a time in which the US really is suffering an economic crisis. But to place that at black women is something that's ridiculous, but that's exactly what he does. And the other thing that takes place during the time in which he's in office is this war on drugs. And that too is blamed on black women. Some of you may recall that. The crack mom who's having so many crack babies. The crack mom and her crack babies, and they need to be taken away from her, and we're spending so many, I mean, the newsreels. If I were to show you some clip, it would be from the New York Times a few years ago, basically apologizing for how it invested in this narrative too. All these newspapers over and over again, the billions, the trillions of dollars that we're going to have to spend on these crack babies. And all of the crack babies are presumed to be the black babies. So you got the welfare queen with too many of her crack babies, and she's a crack mom, and she's just a bad mom, right? These are the kinds of narratives that we were trapped with. So that this group of black women 30 years ago came together and said, enough of this. And enough of thinking about a reproductive rights framework that forgets justice, that forgets important matters such as being able to survive a pregnancy and to have a pregnancy with dignity and not be blamed or not become the pariah, of society. An agenda that is about sex education as being something that is important. Access to contraception as being something that happens to be important, and all of the other kinds of vestiges. Let me say something that I think about, because you've asked about a pathway forward, and that was called reproductive justice. That's what they named it. And I would say that it's a time for a reproductive justice 2.0. And I will say that their vision and their leadership was important because they also thought about LGBTQ equality and the protection of that within this framework. But I'd add something more as I think about it. My daughter now lives in the Netherlands. She just finished her PhD last year. And when she was a high school student, she spent her junior year abroad in China, further honing her Mandarin skills. And I say that not as a proud parent, though I am, but that's not why the story that I'm telling you, which for me, Rebecca, is a next agenda with reproductive justice, or part of it. Before I departed, leaving my daughter on visit with her while she was in Beijing, I bought her a hoodie. I bought her a hoodie because it was cold and she didn't like to wear hats. And I thought, with this hoodie, she'll put the hood on and it will keep her head warm and her ears warm. And it was red and it had a dragon on the back of it, and I thought, this is great. She'll wear the red hoodie with the dragon and keep her head warm. And so as I fly back to the United States, and I'm in a lounge connecting flight, and I'm looking up at the television screen trying to understand, what am I seeing there in this story about a young man named Trayvon Martin. Now that name might not be familiar with some of you, but some of you it may. It's the story of a black kid who was carrying Skittles candy and iced tea and a hoodie while walking home, who was murdered on his way home by someone who believed that he did not fit in his neighborhood. And as I stood there in the lounge, having said goodbye to my daughter and having given her a hoodie and returning to the United States and trying to understand, and I began crying there, that the thing that connected to this young man to death was the fact that he was wearing a hoodie and was black in a neighborhood where his belonging was questioned. And that really gets back to the fundamentals of my talk about personhood, about citizenship, about belonging. What does it take to be a citizen whose rights are recognized.
Thank you. We're going to go over to that side, to the back, to one of our students, and then just a few rows down, yes, you, and then to Brenda Cosman.
Hi,
Is
Professor.
there another student?
Hello.
And did you also have a question? Okay, we'll fit you in before Professor Cosman as well.
Hi, Professor. First, just want to thank you so much for the lecture. My name is Dorian Adeyemi. I'm a 1L at U of T, as well as the 1L representative of the Black Law Student Association here at U of T. I wanted to ask something that was actually sparked by the way that we described this lecture. You said it was depressing, and then our dean said this is thought-provoking. I'm wondering, how do we go about engaging in these sort of conversations when it is like almost this double-sided coin of depressing yet thought-provoking to actually get to critical like conversations and potential solutions to things like this?
Thank you for being here and for that question. My background before attending law school was in the study of sociology and anthropology. And I think I was probably born to be part of that, observing. And in fact, if I'm to reveal even more, I'm an only child. And at some point during my childhood, I think I probably just seemed so lonely that my parents said, okay, let her go visit her grandmother. So my first flights were alone, I think 4 or 5 years old, taking flights down to Tennessee to visit my maternal grandmother. And my maternal grandmother would then, a couple weeks of that summer, at least 1 week, would be going to Mississippi. And to truly understand, and I'm coming to your question about observation. One of the first things that I would observe when we would get to Mississippi to visit my great-grandfather. My great-grandfather died during my second year of law school, never having had running water or electricity in the United States, in Mississippi. I think about how kind my relatives actually were, because when I would arrive, I would tell them, I only drink clear water. And they were so kind to me, because clearly they wanted clear water too, but their water was brown. And somehow, through some miracle, the water that they would give me was find some clear water. And I think about that now. Here's this 6-year-old saying she wants clear water. They wanted clear water too. But the art, or just what was within me to observe, was really important. And so empiricism, I think, is critically important, right? One of the things that I would advise students to do is that you read, learn, and amass the information, and amass the facts. And it doesn't mean that the facts always land in the way that you might want, but it's important to know them all. And I think that there is something that we gain from the clarity that we can get from what knowledge is, from the process of actually seeing and reading, and then it's very helpful. I know your question is one that is about how do we reach some form of understanding when there are different ways of understanding things, right? I can think about that after the 2016 election, for example. I was giving a speech and I mentioned how white women were pivotal with the election of Donald Trump when the contest was between Hillary Clinton and Donald Trump. And whether highly educated or those that were not, white women, more than voting for Hillary Clinton, voted for Donald Trump. And I remember being on a dais with someone that said, we shouldn't talk about that. Who's a white woman? And my point of view is that we actually need to talk about these things if we don't. But of course, what we need to be able to do is to speak with some real knowledge and to speak with evidence that we can have at hand and then figure things out from there. So that may not be, I'm not sure how that lands as an answer for you, but my sense of it is that there is so much power eventually in being able to reach people through actually what it is that we are able to know. It's very hard to contest what the actual facts are. But I will say one other thing is that part of what is a very dangerous time right now in the United States is the suppression of knowledge. The banning of books even written by Rosa Parks, the banning of books written by Martin Luther King, the banning of books that speak to the Holocaust, the banning of books that speaks to the Trail of Tears and indigenous individuals. All of those things make it far more difficult to have more nuanced and informed conversations. And the final thing that I'll say is that Derek Bell has come up a lot in recent years in American politics, interestingly enough. Critical race theory, which is just one amongst many theories of law that are taught in law schools, has become a point of political fodder. And one of Derek Bell's theories is one that is rooted with the thought that it's not until there's some mutual interest of alignment, right, that people ultimately see the harms that need to be remedied, right? I think that there's a lot of truth to that. Next question.
Hi, my name is Shravani. I'm also a 1L here at U of T. I wanted to ask, I believe there are some states in which abortion is a felony, and I believe there are some states in which felons can't vote. And so I wanted to ask, do you think there's a connection between the criminalization of abortion and the potential to disenfranchise women? Is that just but is that a byproduct of the laws against abortion, or do you think that is part of the impetus to ban abortion?
It's a great question. Years ago when I was in the Philippines and I was interviewing a person who led an NGO about the virtual sex trafficking of children, virtual because it was on video rather than physical. So one of the new areas of exploiting or newer areas of exploiting, sexually exploiting children is one in which individuals recruit children from playgrounds. And in the Philippines, interestingly, some of these cases involved parental consent and was to then put children in front of videos and then where people around the world could see them, and there's someone who's multilingual who then tells the children what to do. Really, really horrific. So this person who was running this NGO was a person trying to bring an end to that. And we began our time together with her telling me about how when she was incarcerated by the state because of her political activism, as a form of punishment against her, her children were incarcerated with her. And I thought, wow, that is pretty cruel to also incarcerate the children. Except now for good behavior in the United States, given that there is so much incarceration of women and women in matters related to their motherhood, that for good behavior, your kid gets to be with you in prison. So imagine then growing up behind barbed wire and in a prison because your mother behaves well. The United States incarcerates more women than Russia, China, Thailand, India, and Mexico combined. The United States is a place that incarcerates about, of all of the people incarcerated in the world, about 25% of them happen to be in the United States. And so your question being, what is the motivation behind, some aspects of this? What's the gain out of this? I think from a law and economics point of view, there's not much gain whatsoever. So some of the most helpful arguments that have been made in the space involving criminal punishments in the United States in recent years have come from more conservative think tanks. that have raised the issue that the way in which the United States criminalizes is inefficient. Doesn't make much sense. Some others would come from the point of view that it's morally corrupt and unsound. If you consult the work of Kristen Turney, who is a former colleague of mine at the University of California, Irvine, who's a sociologist, her research and that of others shows that children of incarcerated parents fare worse than children who've experienced a parent's death or a parent's divorce. And US incarceration is so profound of mothers and parents that even on the children's cartoon, or not cartoon, puppet show, Sesame Street, there's now a puppet that has an incarcerated parent, and that puppet is named Alex, and that's how extreme it happens to be in the United States. And the outcomes are not great for the parents or for the children.
Now we have really gotten going, so I think we're going to go to Chelsea and then to you in front of Chelsea, and you're happy to yield, it sounds. So please, let's hear from more students.
Hi, Professor Goodwin. Thank you so much for being here today. My name is Chelsea, and I'm a second-year student here. And my question is just to clarify, I think, a key point that you mentioned, and it's around what's happening in the US today. And I think you've been clear that it's not just about the last couple of years of what's happening in politics, but more about the long history of the United States and enslavement. And so then my question is, so is what we see unfolding today about is it targeted about the non-personhood of women of color, or is it about the non-personhood of all women, of which women of color happen to be disproportionately victimized?
Yeah, I would say that women of color and black women in particular have been what I call the canaries in the coal mine. They've been the conduit for what is taking shape today, that if we bother to pay attention to them, then we could understand what is yet to come and that would affect other persons. There have been those that have argued, a very good colleague of mine whom I adore, Kiara Bridges, has said that the type of policing and punishments that have taken shape really are a matter of explicit disregard for the lives of black women. And certainly if you look at what was taking shape in the United States in the 1980s and the 1990s, that would be hard to refute. And certainly one could say, given the grave disparities between black and white women with regard to maternal mortality that has yet to be fully addressed in the United States, that too would make it seem that the disregard really happens to be about black women. But my sense is that what is taking shape is something that is much broader than that. And that ultimately, these are matters that really affect power, that it's power and control that is at the heart of what it is that we're seeing today in the United States.
Thank you.
Mm-hmm. You're welcome.
Hi there, my name's Aiden. I'm actually a second-year student, undergraduate student here at U of T. And my question kind of leads on from what you just said in the final remark there. Actually, I wanted to preface my question firstly saying thank you for being here. I found your talk,
Thank you.
It was really, really great. But my question is, I find myself watching and reading the news a lot, and I see these developments related to gender issues and sexual violence issues in the States, and and also all over the world. But I find myself asking a lot, why? I just can't understand it. So my question is, are these issues, are they primarily about values, people's values that are misplaced? Is it misogyny at the core of it? Or could you expand a little bit on how it ties into greater power structures? You made the comment there at the end to the last question, but I'm just wondering if you could expand on that a little bit. Because from the outside perspective, it could also be a reflection of the fact that I haven't studied the issue, so I don't understand why it's happening. But yeah, I just keep asking myself why. And I'm wondering if you could maybe enlighten me a little bit on that.
Yeah, I appreciate that. It's been a long time thinking about the why. And part of what we see is really hard to justify, right? So if if what we see with the policing of women's reproduction in the United States is truly about protecting fetal health and then childhood development, then one might see greater economic support coming from state and federal government about children, right? But that's not what we see, including in the state of Mississippi, right? In the United States, we don't have universal health care, and the closest that we get to poor people being able, people who are economically disenfranchised, being able to have access to greater health means is through an expansion of what we have as a program called Medicaid, government-funded health care. In the very same states, you could draw Venn diagrams of the states that have passed abortion bans, refuse Medicaid expansion. So it can't really be perhaps about protecting the health of either pregnant women or people with the capacity for pregnancy, or about the children born afterwards if there is a refusal to expand health care coverage. Is it really about the abortion bans of protecting women's health, which was the argument that Mississippi used in the enactment of its law, that it passed its law because this was about protecting the health of women? Well, can that be true when in the United States a woman is 14 times more likely to die carrying a pregnancy to term than by having an abortion? It would seem that that's actually not true. So then ultimately, what truly is this about? Is it a matter of a form of a kind of political gerrymandering? Is it a sort of part of, and what I mean there by a form of political gerrymandering as a moment in time when there is a consolidation of groups that that don't share all interest, right? So more vocal in the United States in recent years have been Christian white nationalists who have not always had the kind of access to the kind of political access that they have now, but are a group of people that since the time of Roe v. Wade have articulated their opposition, but not always with the platform that they have now. Now it's a group of people who want to hold and preserve power, who would have been part of a community that previously would not have aligned with Christian white nationalists. I think what one sees is a coalition, perhaps fraught coalitions that won't always stay together, and I don't think they will. I think that this is a time that will ultimately pass. I do think that we will get to what might be a third Reconstruction. My question at that time is how one actually holds on to it. But I think that ultimately your question about what explains this, is this just plain old misogyny? I think that that's a start, but I don't think that that's exclusively it. I do think that it is about a return to a certain kind of power. And it's interesting what's being spoken to in the United States recently about, well, it's not really necessary that all people have a right to vote. Not everybody is really an informed voter. And those are questions that are not just race-based, right? They aren't. And then that too connects to something that is of a past. And that past happens to be that the first suffrage movement in the United States was not amongst women. And then those of you might wonder, well, who were those suffragists? They were white men who had been denied the right to vote because they didn't own property. And it's very interesting to hear some of these arguments now being made by certain elites, right, who have access now to the president-elect, suggesting not everybody needs to be able to have a right to vote. Not everybody is invested, as others are, in being able to vote. And I don't think that that's exclusively about race.
All right, I know, I think we unfortunately have to wrap up, but I want to thank you for sharing yourself with us and really the profound wisdom that comes through everything that you've shared with us tonight. You said in the context of one of the stories or images that you evoked for us that it was crystallizing. So to me, that is actually the word that stands out with respect to the remarks that you've offered and your engagement with us here. It's crystallizing because some of it is, a lot of it is depressing. You are not armed with, but you have facts for every question, but also above all stories to make the facts come to life and to make them real. And so in that sense, I think everybody's going to walk away thinking for the rest of the evening and probably a lot longer and wishing to continue the conversation. And I know there was one more question, and I hope you'll feel free to have the conversation once we all thank Michele Goodwin.
Thank you. Thank you.